You have to sell a project to a policy advisor who is usually a very young, very bright person.
It's like the Dragon's Den.
Yeah, exactly. It is. And as soon as you say the Bills of Exchange Act 1882, you can see them looking at their watch, eyes glazing over. People were spending all sorts of money on NFTs, Beeple and the Bored Apes. You would presume that if you hand over money, that you're buying it in the way that you buy a Rolex. There were so many points at which I thought we're going to lose this act. I think I might be the only law commissioner whose bill saw 2 monarchs, 3 prime ministers, and 5 Lord Chancellors.
Today, I'm speaking with Professor Sarah Green. Sarah was the law commissioner for commercial and common law of England and Wales. She has led landmark legislation reform, such as the Electronic Trade Document Act 2023. We first learned why she was the best person for the job. Not many people can claim to have studied law at Oxford University, helped build PlayStation.com, and taught international sale of goods. Then we examined why the UK law requires a surgical approach to legal reform. Less is more. This led to the question of reliability. Why did UK take a different path than France? We discuss if there are indeed property rights for digital assets. If you have poured all your savings in NFTs or crypto tokens, wouldn't you want to make sure that what you own is truly yours? Is it too late for UK to truly embrace digital assets with sound regulations? I hope you will enjoy this conversation as much as I did.
Just to make sure that we are ready for the podcast today, I also bring up 2 books. So can you guess what they are? So first one is in Chinese, unfortunately.
That looks like the MLETR, is it?
Very good, very good. I have the English version also. So obviously today, I'm very excited to talk to you about MLETR because it's one of the most important legal change that's impacting global trade and directly for GSBN. And that's something that I kind of become a bit geeky about it. And I have to say, before the formation of GSBN, our experience with lawyers is not great because lawyers typically are blocking, making sure that we can do things. But this is something to enable us to do things. So very happy to talk to you and understand a bit how that came to be. So to get us started, can you introduce a bit more about your background? I think before you became the law commissioner, I understand that you started first off as a programmer at Accenture. Is that right?
Yes. So when I first left university, I did do a law degree. But then I didn't go straight into law. I worked, you're right, I worked at Accenture as a software developer, essentially as a coder for a few years, which probably explains my relatively unusual interest as a lawyer in technology. There aren't that many private lawyers around who are interested in technology. But that was, I suppose, a bit of a left field move. Certainly at the time, everybody expected me, including me actually, expected me to go straight into law because I did really enjoy law. But it was a really interesting...
what prompted you to become a software developer? What was that? That was 2000, early 2000 or 1990s?
Yeah, well, no, before that, it was 1999. So that ages me, doesn't it? It's 1990. But that's really interesting. So the time, I mean, so that answers your question, really. So it was the dot-com boom. So it was, such an exciting time to be working in that area. And in fact, again, this is going to age me, but the major project that I worked on, and my students these days, and certainly my kids find this kind of hard to get their head around, but we were building really the first B2C website, and it was for Sony. It was to sell PlayStations on the internet,
really?
which then was, a brand new thing. You couldn't really buy things on the internet then. So we built the PlayStation.com where people could buy their PlayStation, and it was still PlayStation 1. I think towards the end of the project, it became PlayStation 2. But so obviously that was just such an exciting time to be in any sort of technological environment because it really was the center of the dot-com boom. It had all gone crazy. It was all super exciting. And it was also partly, companies like Accenture are very good at this. They go around universities and sell themselves and say, if you come and work for us, you're going to do this, this, and this. And it was a super exciting job. I got to travel. They send you to Chicago to train, to learn how to code, basically. And they take everybody, all different countries, and you're put in a classroom. It's sort of like Freshers Week, but with a really difficult day of work going on as well. But, it was really exciting. I got to go to Dubai. I got to work in Ireland.
Really?
I got to work in Germany. it was a crazy few years, but I learned so much because I had never done any coding before. And it was a real sort of a very steep learning curve. I mean, you really are put in a classroom for 12 hours and they give you an objective. And, as soon as you manage to build what you need to build, you can go. So there's a huge incentive to get there. I wasn't a natural coder, I think it's fair to say, but I'm really, really glad that I did that. I went back to law afterwards, but it gave me an invaluable insight into how coders think and then, how machines work and how machines think. And so, if you fast forward a couple of decades to when I've been thinking about the law as it relates to digital assets and smart contracts, it really helps to know how those things work. Like I couldn't build a website now. I'm sort of 20 years away from that, but I still remember the sort of logical architecture. I remember the basic principles. And it was that job really that made me realize that the law was not going to be able to cope with what was coming, in technological terms, that things were going to change so fundamentally that the way we apply legal rules was just not going to work in the digital age. So it was a strange, some might say quite a sort of a strange little tangent in my career, the rest of which has all been about law. But it fits very much with what I've done in recent years, certainly at the Law Commission.
Do you mind me asking, actually, so I'm really curious about this because what's really interesting in your case, you went to programming, but you were trained as a lawyer, right? And you didn't know coding. So which language did they teach you? And then what prompted you to make that change?
It was, I'm trying to think actually how similar those two, law and coding are, and that there are some overlaps. I always say law is a bit of an art and a science. You need a bit of both, and there is quite a lot of overlap in terms of some of the sort of logic and rationale you have to use. And I'm sure the sort of non-lawyer idea of lawyers is being very pedantic about particular terms and terminology. And of course, as a coder, you really have to be very exact because there's no contextual interpretation that can be done by machines. And in that sense, it's the opposite end of the scale, because when you're a lawyer and you present a meaning, the whole point of your opposition or the whole objective of your opposition is to argue that interpretation doesn't work. So there's a big sort of, you think about a Venn diagram, there is definitely an overlap in the middle, but the other two spheres are quite far removed. So it was partly curiosity. I've said before that my career has really been a series of happy accidents. There was never a plan. And I'm sort of a bit of a magpie in the sense of if I see something that looks exciting at the time to me, I'm quite tempted to go and do it. And I never, a law professor, I never imagined I'd be a law commissioner. I never thought I'd write books about law. So it really was that Accenture came along. I thought, I've never done coding. I'd really like to code. I had a sense that technology was going to be a big thing. And I know that sounds silly, but in 1999, it wasn't that obvious. Or it certainly wasn't that obvious in the circles I moved in. Yeah. So it was just that it seemed intriguing to me. And I'd done 3 years of quite intensive law study. Yeah. And I'm also, I quite like change. I quite like new things. Coming along. So I think it was a combination of all of that took me from one to the other. But then, of course, it's quite interesting because when that had finished, I was quite ready to go back to law and immerse myself in that side of things. And you mentioning shipping, I think this is one of the happy accidents. So when I went into my first legal academic job at the start of, so it would have been around 2003, I think, one of the subjects that they wanted me to teach was, what was it called at the time? International sale of goods, which was essentially shipping. I mean, that's, that was, and because I was a contract lawyer, so I did contract tort and property, that seemed like I seemed at the time like the obvious person to give that course to. I sort of inherited it from someone who taught it for years. So I had to teach myself all about shipping. And, that was really interesting to me and sort of got me hooked on that interaction of what you've got going on there. You've got, it's perfect really because you've got contract law, you've got tort law, you've got property law, you've got other things as well. But those were my subjects. And so, I really enjoyed that. But I think that was simply the head of school at the time trying to fill a teaching need. And it worked out really well for me because, I used it throughout the rest of my legal career then.
Yeah, it's super interesting. It's almost, that reminds me of the story that I don't know if it's real apocryphal, where they talk about how Steve Jobs, when he was in university, he learned about calligraphy at Reed University. And later on, that's what created him to design the font for the Mac computer, right? And actually you don't know the path. And for a lot of people, it's all about connecting those dots. that later on you may use. From you say, it almost feels like you were set up to take this role of law commissioner to do ETDA because you have the computer science, the coding, you have the industrial trade, you understand the different dynamics and the requirement. It's almost like the role is designed for you, not the other way around. So first off, define what is a law commissioner for people who are not familiar with UK law. What's a law commissioner? What's the role, and how typically this role are created? Who appointed to this role?
So that's a really interesting question, because I think the Law Commission in England is quite unique as an institution. So essentially, the Law Commission was set up by statute in 1965 to review the law of England and Wales and to make sure that it remains modern and accessible, so basically fit for purpose. And there are 4 law commissioners at any one time, and they all have different areas that they cover. So I was commercial and common law, also known as COCO. There was a criminal law commissioner, obviously looks criminal law, property, family and trusts all in one, which is quite broad, and a public law commissioner. And so we all had our own areas. Now, it's funded by government, but it's independent from government. That's really important. So all of the research that we do and the proposals that we make are not political. In fact, we don't take on projects that are going to have a real sort of political controversy to them. And the point is that you then make recommendations to government that government can obviously do what it likes with. It's highly consultative and it is genuine consultation. So our first set of proposals are the result of consultation. What questions should we be asking? What are the problems? And so we come up with proposals, then we consult again on those proposals and then come up with recommendations for government once we've looked at the responses to consultation. And as I said, it's definitely a genuine consultation. Our final proposals very often look different to the original set that we came up with. We can also recommend and write our own draft legislation for government, and we quite often do. In fact, you mentioned a couple at the beginning. So the Electronic Trade Documents Act, we drafted that in the Law Commission and then presented that to government. It goes then through the parliamentary process. And there's also 2 more that happened during my time, was the Property Digital Assets Bill, which you mentioned is what encourages the law to regard digital assets as the object of property rights, and also an updated version of the Arbitration Act. So we do those things, we present them to government, and then government takes them, if it wants to, takes them through the parliamentary process. So law commissioners are what are called public appointees. So similar in many ways to judges. They're not civil servants, they're independent, and they're appointed by the government. Our appointments have to be signed off by number 10. I suspect that the actual mechanics is far below that, but we do need the signature of number 10. And by that I mean the Prime Minister's office. That was a very English way of talking about it, sorry. And law commissioners they're either academics or they're people who have practiced law, so that they've been practitioners. Yeah. So it's a very interesting body. I think it's very unusual. I mean, I know this sounds like a bit of a cliche, but it's so true. I felt very privileged to do that job because a lot of my academic work has always been about how the law should change and recognise technologies. And, you can write as many articles and books as you like, and you hope they get cited in court cases or, in Congress or in Parliament. And sometimes that happens and they can have they'll have a bit of an effect. But as law commissioner, whole job, all day, every day, is looking at law reform. You have this amazing team of lawyers and research assistants at the Law Commission. We work with other comparable bodies across the world. And we certainly did that with digital assets because, of course, it's a global issue that everybody's facing. And it was quite clear to me that we were very lucky in England and Wales to have the Law Commission and to have a body which is just full-time being able to look at these things. So a lot of jurisdictions were having to do this using people evenings and weekends, persuading academics or persuading practitioners to do it in their free time, which, no matter how brilliant you are, there's just a limit to how much you can do when you've got a different day job.
So actually explain a bit to me. So when you were appointed as law commissioner, did they tell you, okay, Sarah, I want you to work on ETDA, or what became ETDA? Or it was free for all, you get to study or investigate which area you want, and you're like, great, I have something I wanted to do. I wanted to do for the last 15 years. So let me jump on the opportunity. So how did it come to be?
It used to be the case that law commissioners could just decide, I'm quite interested in this. I'm gonna do a law reform project on it. Since 2010, there's been a protocol in place which says that pretty much the Law Commission will only work on projects that the government has expressed a real interest in. And, for resource reasons, that makes sense, really, because the government, as I said, funds it. So one of the things that I wasn't expecting when I was appointed was how much of a sales job I would have to do as a law commissioner. You did ask me before and I didn't answer it, sorry, that I think one of the reasons I was appointed was that there was definitely a sense that commercial law and common law needed to change to accommodate what were at the time referred to as emerging technologies, Web3. I mean, it wasn't put in these terms, but essentially Web3, blockchain, smart contracts. So there was a sense that that's the sort of thing that needed to happen. And of course, that was, as I've already said, that there aren't that many private lawyers who work in that area. So wasn't a huge pool from which to choose. But beyond that, the actual projects themselves were down to, I think this is true for all of the ones that we've mentioned, my team and I putting together a pitch, really, and persuading. But you have to sell a project to a policy advisor who is usually a very young, very bright person, but they're not always lawyers, and they're it's very time pressured, and you basically get about 20 minutes. And you get about 20 minutes to sell a project to somebody who is
like the Dragon's Den.
Yeah, exactly. It is. And it's like, take the Electronic Trade Documents Act. I mean, obviously it's my baby. I think, clearly it's super important. But trying to sell that to a non-lawyer where you've got to explain the whole thing about personal property. You've got to explain why that's important in international trade. And as soon as you say things like the Bills of Exchange Act 1882, you can see them, looking at their watch, eyes glazing over. Because why wouldn't they? Because it just sounds really dry. And if all you've got is 20 minutes to sell that, it's that I found the hardest, I think. When as an academic, you at least get an hour with first years to explain, why contract
you said the proper context. Bring the story.
Exactly. And you can give them loads of examples, and you can, you can't do that in 20 minutes. So it was the electronic trade documents, the digital assets came from within, came from the work I'd done before in smart contracts. Or the stuff that I'd sort of suggested that we then sold to government. We also at the Law Commission get suggestions. So we listen to anyone. I should have said that with the consultation. It's a totally open consultation. Absolutely anybody can respond and can suggest projects. That's the other thing. You can write to the Law Commission or email the Law Commission and say, I think this needs looking at. A couple of my projects came from suggestions, either from government or from someone else in the team, and some Law Commission projects come totally externally from, say, the business community. And in fact, that was really helpful in selling the ETDA to government, because once the International Chamber of Commerce joined us for a few events.
Chris Southworth.
Exactly. So he and I were at an event quite early on in my tenure, and there was somebody from government there, and Chris and I made the point, and this guy said, why is this not already happening? It's such an obvious thing. And we were like, that's kind of our point. So as soon as, particularly business, and, the International Chamber of Commerce was great. ITFA was great. Really good at persuading government that this wasn't just my bugbear as an academic. It wasn't just a thing that I'd been writing about because it really bothered me intellectually, that this was a seriously important global issue, and that's what government obviously is going to listen to, because once you get numbers involved, and that's not my area, but that's definitely Chris's, that's definitely the IC's area, and they just showed what a huge difference this legislative change could make. And it's so cheap, really. I mean, it's massive in terms of its effect, but the ETDA is 6 substantive provisions long. Like, that is such a short statute. And the digital assets one is only 1. But these are, I really want it. I'm a big fan of being concise, except when I'm talking, as you can probably tell. But when I'm writing, I'm a big fan of being concise. So I wanted all this legislation to be as short and as pithy as possible. So actually, it's a small textual change, but it is, quite significant in terms of its effect.
I think that could be also because you were trained, because the good coder don't try to write very long long code, but try to be as concise because they have to reread the code a couple of years down the road. I'm sorry, but the image I had in my head is I'm a big fan of British TV shows. So there's two TV shows comes to my mind. One is Yes Minister. The other one is The Thick of It. So I'm sorry. So I just couldn't stop laughing when you're saying you're pitching to bureaucrats to explain why they should care about the ETDA. So that must be really an interesting experience.
Hey, Zach in the editing room here. I realize that 76.8% of you have not yet subscribed to the Schelling Point. If you could just hit the subscribe button down below, it will really help us out and keep producing content like this. Thank you. Now back to the Schelling Point.
Do you know, I'm the same, and particularly Yes Minister. I mean, there were days when I just used to say to my team, I feel like I'm living in an episode of Yes. It is uncanny how true to life they both are. Actually, both of those programs are very, very true to life.
Accurate, accurate documentary, not parody.
They are, yeah. I mean, obviously, not everybody, but there is definitely a huge amount of that. I mean, they clearly were written by somebody who'd worked in the civil service. There is no question in my mind. Yeah,
for sure.
I mean, it wasn't always quite that funny, but it was definitely, it definitely felt like that. Yeah.
Okay. So let's dive deeper in the ETDA, because I think that's one thing that impacts us more. And I also want to get more your opinion, understand how it came to be. So I think the first step before we talk about ETDA, which is a change to UK law, I think people need to appreciate why UK law is so important for global trade. So maybe can you explain a bit why, historically speaking, UK law is so dominant and so important for global commerce?
Yes, this figure gets used a lot. I'm not quite sure of its exact source. I suspect it was partly from the International Chamber of Commerce and their economists who have these huge, vaults of figures. And it is still the case that around 80% of international commercial transactions use English law. So the thing that not everybody who's listening might appreciate, because it's not that obvious, is that you don't have to be in England or really have anything to do with England and Wales to use English law. I mean, as contracting parties, not totally, but to a large extent, you can say you want any disputes that arise from this agreement to be governed by the law of England and Wales. And as I said, you don't have to have anything to do with England and Wales. You can just say that. And in many cases, that will then be applied to your dispute, which is why there was such a compelling case for the UK to pass the ETDA because of all the systems. And in fact, when I spoke to my counterparts in other law reform bodies across the world, it wasn't uncommon for them to say, we're waiting to see what England and Wales does and then or what the UK does, because it was then with the Law Commission of England and Wales, but some of our legislation then gets adopted across the UK and the ETDA is one of them. That's what I was told several times. We're waiting to see what English law does. Why is that? I suppose it's a combination, really. I mean, obviously, there was the old sort of colonial effect from many years ago. But I think, although clearly that's no longer a thing, I think the point is that the legal sort of intuitive response remains. And partly that is because to be sort of a substantive lawyer about it is that, of course, precedent is very important. I think there's two things that are sort of substantively important, because, of course, those are the procedural aspects, which we should absolutely not underestimate. Very strong adherence to the rule of law. That's a very sort of English law thing. I'm not saying it's only English law, but it is definitely something that English law really, really values. But I think when it comes to commercial law and when it comes to contract law, we have our common law system obviously is responsive and sensitive to change. But commercial and common law, there is such a strong ethos of certainty and predictability. I've said so many times, I talk about contract law a lot in, the lectures and talks that I give. And I often describe, in fact, I always describe contract law as the cockroach of the common law. Everything changes, economies change and mores change and societies change, but contract law does not change. It just carries on. It is so predictable in terms of its rules. Obviously there are going to be some parties listening to this who might say, well, that didn't work for me. But on the whole, English contract law is incredibly certain and dependable. And that is, there's a really strong underpinning of that. So, what it comes down to, I suppose, it's partly the effect that, parties are just used to saying England and Wales. There's a bit of that. But there is also, I think, a sense of really knowing as a commercial party what you're, in as much as you ever can, really knowing what it is that you're likely to get. So it's that legacy, I think, that explains the sort of significance of English law in the international commercial marketplace. It's quite a common thing to have recourse to England and Wales as a seat. So it's multifactorial, but I think those are the things that, in my mind, are probably what leads the charge on that.
Yeah. So actually, it's very close to programming language. It's how do you build the building block to create a function that can perform different tasks. And the way that UK law built is very robust in the sense that it's very simple. And there's a lot of case law that actually helps create certainty because of precedents. And there's a kind of a back catalog of cases that basically start to cover every single possibility that can happen. And in the case, there's a case that's not covered. Well, you know what? We have a new precedent to cover this new case to make sure it's always relevant. And that's why it's so robust. And I think the network effect is more coming from because it's so robust. And historically, there were so many countries trading with you. Then you have a lot of country jurisdiction who has to use this law. And then they train their lawyer following UK law. And then you have this body of judges, good judges who are well trained, who can arbitrate, who can adjudicate correctly. And that's why it became popular. And once you have that, it's very hard for something else to spring out and replace that unless you're having good judges and have something that's very flexible that has stood the test of time. Yeah. I think that's sort of what you're saying effectively.
Yeah. And also, of course, lawyers are famously risk averse. And, as humans, we tend to prefer the risks that we know, familiar risks. And so at least with English law, obviously there's a risk, there's always going to be a risk, but it is a familiar risk. Whereas if you're going to choose a whole new legal system and a whole new jurisdiction to cover your transaction, well, that's a whole new load of risk that you're not used to. So yeah, I think it's fairly entrenched now, really.
So if you're double clicking on this one, the ETDA, right, is basically to make sure that you can have a digital trade document. Why we had to do a bill, why you couldn't use case law to address it? What makes it so specific? You had to do a bill.
Yeah, so really important question, because what we were working on at the time was the Electronic Trade Documents project and digital assets together, but they're separated for exactly this reason, plus the fact that the digital assets project is broader because it covers a wider range of digital things. But, and this goes back to trying to sell this to government in 20 minutes, because this is about the Bills of Exchange Act 1882. So that's how long we go back. And this fits in with what we've just said about how commercial law is, goes so far back. We've got all this case law built on that statutory that statutory foundation. The problem for electronic trade documents before the 2023 Act was that the Bills of Exchange Act, and quite often what parties are going to want to use is electronic versions of Bills of Exchange. That Act, nearly 150 years old, required documents to be held and delivered, and so essentially possessed. So in order to meet the requirements of the Bills of Exchange Act, these documents essentially be amenable to possession. And then we've got, because of course we've got this sort of dual system, we've got statutes, and then we've got the case law interpretation of those statutes. And as recently as 2009, we had a House of Lords authority that said if something's intangible, it can't be possessed. Therefore, the intangible, if that's how you see an electronic bill of exchange, as a lot of people do, if it's intangible, it can't be possessed. It therefore cannot be held and delivered, which is what the Bills of Exchange Act requires. And you cannot, in this system, you cannot change a statute through case law. So statute prevails. I don't know how. I think that's fairly common across the world, but it might not be in every jurisdiction. So you need a statute to change a statute. So that's why we had to go through the parliamentary process, because of the Bills of Exchange Act. So we just needed to make it the case that electronic trade documents could slot into. So this is the really important thing. What I very much had in mind as Law Commissioner is always, given everything that we've said about English law and how valuable it is as an export, I didn't want to break it. Yep. You don't want to go in and try and make one thing better and then break the whole thing. So I often describe the ETDA as laparoscopic legal surgery. It was just enough. We wanted to do this 6 substantive provisions, just enough to make sure that those electronic trade documents could then slot into the centuries of other stuff that has worked really well. And you know, is that basis and is that continuity? Yeah. And that's what the ETDA Act does. It looked, in essence, just because these things are electronic in nature, as long as they fulfill the following characteristics, they can slot into all that precedent and all that, you know, law and jurisprudence that we have about commercial law and commercial documents. And we don't have to reinvent the wheel. We don't have to go back and start again. We can just slot them in. And that's exactly what that act aims to do. But yeah, the reason it had to be an act and have to go through the parliamentary process was for exactly that reason. Whereas for the wider digital assets project, where the broader question is, if you take a digital asset, which of course might be, because the thing about electronic trade documents is they have an absolute paper analog. So we're used to trade documents and we know what to do with them. Whereas if you take like a non-fungible token of any description, there isn't really an existing thing for that in law. And there's certainly no statute that applies to it. So when we made our digital asset recommendations, we could do those in terms of common law, which is, I think, better for a lot of reasons. It's more flexible. Allows so for the law itself, it can be better, but it's definitely easier as a law reformer because the parliamentary process is a mission, basically. You know, it's a proper mission. And in fact, even though it wasn't very controversial, nobody really objected to it. I mean, why would you? You know, unless you were a paper manufacturer, there's no reason to object to. There weren't really any losers. It wasn't mandatory. You know, it doesn't make people use electronic trade. But despite that, it had such a rocky journey through Parliament for reasons totally unrelated to its substance. It was a very rocky time in government. So I think I might be the only law commissioner whose bill saw two monarchs. So it was nearly passed when Queen Elizabeth died, which of course the whole thing started again. So we had two monarchs. We had 3 prime ministers, I think, during that time, and 5 Lord Chancellors, or at least 4 Lord Chancellors and 1 who came back. So, and every time something like that happens, you know, the whole parliamentary process is, so for reasons, I think it was the rockiest for us, you know, in England, I think it was the rockiest time constitutionally. So there were so many points at which I thought we're going to lose this act. And I was very worried. I'm a big sleeper, but even I lost sleep over just, you know, getting that bill listed, getting it back on the floor, getting it back in the House. And so I was incredibly, incredibly relieved when it finally happened. I might have had a few drinks that night.
So it sounds like you didn't face as much negative feedback or pushback from the industry when you're pushing. What's the process typically?
So a law commission project from inception to completion is usually 18 months.
Wow.
So we do 3 months each. Once we produce so we consult, as I said, to produce proposals, so what we call a consultation paper. Yeah. And then once we've released that, we have a 3-month consultation period. Then we spend about 6 months analysing the responses. And then we come up with the next stage, which is the report. So each of those phases requires at least 3 months where we have it open for consultation. So it's 18 months in total. And I think, as I said at the start, it's very important part of the process is consultation. And I think that's one of the reasons that by the time we got to the parliamentary stage with the ETDA, there was no longer any substantive objection. That is certainly not to say that we didn't encounter any at all. So the biggest, as we were going along, certainly after the consultation papers, was some concern from the P&I clubs and from other insurers who were worried that our reforms would essentially say, to be an electronic trade document, any document will do. I mean, I think that was their point. We don't want somebody just sat in their parents' basement, you know, writing electronic trade documents and then, you know, which obviously, totally makes sense. Yeah, it's a totally legitimate concern. But we then explained during the sort of 2-way consultation process, really, there was absolutely going to be a threshold in terms of reliability, in terms of what the document has had to do. Yep. And it simply would not be the case that anybody could create a PDF and then go and claim, you know, goods off a ship or pledge that PDF to a bank. Yeah. So we explained that, and because we talked to lawyers, we talked to insurers, we talked to technologists, we were also able to give them examples because we'd already spoken to a few technology platform developers who obviously already had this as a solution. They already knew how to achieve it. So we were just able to say, look, this is perfectly doable now. And this is one of the reasons why we're now doing this project, that you can solve the double spend problem now in a way that we couldn't, at least at scale 20 years ago. So that was really valuable, and it meant that by the time we got the bill to the Parliament, that they were happy with what we'd explained. Yeah. So that was really good. The other objection that I encountered a huge amount for the first few years in both projects actually was, digital documents are quite fallible because what if the server goes down? I mean, yeah, that's, the server might go down, but the server will come back up and the document is very likely still to be there. Whereas, what I always had to say was, you've got to compare it to paper.
Exactly. Paper can burn.
If we constructed this system now, in 2025 or 2022 as it was then, and suggested doing it with paper, people would think you were unhinged. Why would you do this on paper? As you said, it can get burnt, it can get ripped, it can get lost. It's so easy to forge. I mean, the idea that that paper is in any way superior to an electronic document in terms of its integrity, in terms of its auditability. I mean, this goes back to my point about familiar risks, unfamiliar risks. In aggregate, of course, electronic documents are risky, but they're a lot less risky than paper documents. And it's just that they're new risks. And of course, once we start talking about blockchain, and once you explain the technology and point out that actually you're not just going to lose it. We're not talking about 19s word processing programs where, if you didn't save it every 5 minutes, you lost all your work forever. That's just not really a thing anymore. And it's certainly not a thing at the sort of commercial and technological levels we're talking about. But that again, I think shows just how valuable that consultation process is, because by the time we got to that stage, I mean, and the PI clubs, of course, are massively important in this. It wouldn't have worked without their support and without them being on board. So that was good, and it was really good for us as well, because sometimes I was a bit blinkered. I'll admit that I'd been thinking about this stuff as an intellectual exercise for the best part of 2 decades. I was like, we just need to get there. Why would you not think this is a good idea? So it was really valuable to realize that not everybody thought in that way, and that not everybody appreciates what's technologically possible, because, of course, to go back to the Accenture thing, I think if you've never worked or really been involved in the world of technology, I don't think you do realize quite what's possible.
I can share something on this one. It's really funny because for the incorporation of GSBN, when we set up the infrastructure where we negotiate contracts, and there's some provision that some of the lawyer wanted to add. I was like, that scenario cannot happen. If it happened, we have nothing to do. We can all go home. But what you said, it makes a lot of sense. And I think that's probably where, as someone who understands technology, you are better appreciating if this risk is something that's meaningful or not meaningful, right? And I want to double click to the consultation. That's quite interesting, because is there any feedback to receive from the different stakeholders that actually made you change your mind? Is there one example you realize actually that's actually a good valid point, and the design we should change, we should amend the design to adapt to this?
Yeah, I mean that happened a few times. I mean not in terms of the sort of overall objective, but yeah, if anyone has the time and the inclination to compare the consultation papers in both projects, the 2 projects I've just mentioned, to the final report, there are some pretty serious changes. So I think electronic trade documents, probably a little bit less so, although they were sort of more nuanced, fine-grained questions. So one of the questions we had that we were quite interested in terms of consultation responses for ETDA was to what extent we should set out what a system should look like. So, a reliable system is used to achieve the following, and that's where it talks about singularity and divestibility. And one of the things that we consulted on was to what extent the statute should say what a reliable system is. And certainly if you look at jurisdictions and other jurisdictions who've done this, there is a different approach to that. And, France just this week.
Exactly. Just last week.
Has done this in terms of an implementing decree. So their decree 2025-118, which sets out in what we would say is regulation rather than statute, what a reliable system is. So that was something that we ended up putting in the ETDA, an indicative list of factors. It's not very English really to sort of prescribe or say a system is only reliable if it's accredited, because that of course is another option. And we did ask about that. And the general response was, no, we don't think systems should have to be accredited, because it's not, as I said, it isn't really a very English way of approaching, and it would create another bottleneck, because there would then be a queue
who's accrediting
system.
It?
And we wanted the market to remain nimble and agile and to keep providing and producing the best system that could be possible at any one time. But what we did do is we ended up putting in the piece of legislation that wasn't there in our original suggestion, an indicative list of factors, which we were told by consultees would be helpful. And then, but just to give you another more dramatic example of how important consultation was to what we did, when we were looking at digital assets more generally, the question of, so in English law, you've got, the problem always was you've got things in action, totally intangible things like contractual rights. Then you've got things in possession, which are your watches and your laptops and your bags of gold. And, where do digital assets fit? Initially, and certainly when I'd written about this in the past, I'd always said, well, actually, digital assets are more like things in possession, for various reasons that I'm sure we're going to go into later. But I had always argued that it should be treated like things in possession. And so that was one of the questions we asked in the consultation. And once I read all those responses and analysed them, that actually it would be cleaner and for various reasons, a better idea to have a third category, just have a clean, separate third category and not be hampered by having to stick to this dichotomy that, grew up in a time which predated digital assets. I mean, and so there was a real, that's why I sort of emphasised the point that these consultations were absolutely genuine, and they were great for us because we were learning what the market wanted and what lawyers and users wanted, because there is always a danger, I think. I mean, obviously I was an academic previously. My team was a mixture of academics and practitioners, but there is, when you're sat in an office all day, every day, you're reading the practitioner text, you're reading the cases, there is a danger that you're just going to come up with a solution that is intellectually and conceptually very elegant. But, we'd speak to, there was a lot of, partners from law firms who do advise on this, all day, every day. And they a few times pointed out to me why, my conceptual solution might look quite nice on paper, but it wasn't really going to work, or it maybe wouldn't even be needed. That was the other point. This is not a point really that parties are likely to take. So that's, consultation was huge, and it made a huge difference.
Now that's super interesting. And since you talk about reliability, I was going to ask that question. But that's actually a really interesting concept, because I think there's really two camps, right? So it's basically your approach, which is reliable is reliable. You know what reliable is. I'm not going to define what reliable is, which to be transparent with you, I prefer, even though I have a French passport. I'm not sure the French decree is the right way to solve it. I'm going to make enemies. But so the way I think about it, to use reliability or not, is I think there's two aspects that's, to me, maybe your design superior to the one with the decree, is that indeed decree provides certainty in the short term because there's a clear definition, but it's unlikely to matter over long term because things changes. You may actually introduce a constraint that may not be valid anymore in a couple of years. The second thing, which I think is the biggest problem, in my experience for digitalization innovation, is really two approaches to do it. Historically, though, it's the American way to do things, which has been more, let's enable innovation, right? We don't mandate certain things. Let's try the thing and provide an environment where you can experiment, you can figure out, obviously with guardrail, right? We don't want people to do the crazy stuff, but where we let the market figure out some of the aspects where we don't have really to prescribe, or a more European way, EU GDPR way, which in this case is EIDS 2, where you prescribe this is the 5 condition, this is the check mark you need to have, and if you don't have that, it doesn't work. If you look at historically what has happened, the approach which is more pro-innovation tend to work better because it's very hard to predict which direction the market is going. I hope I'm not giving you the exact same answer as you're going to give, but that's how personally I'm thinking the difference between two. And there's no problem per se, right? Because I understand why the French law went that direction, because they want more certainty. So the idea is if we make it more clear, you have more certainty. But maybe by doing more certainty, you're actually creating more problem. So that's my thing.
I completely agree with you. And actually, this is the point. So to go back to your point a while ago about lawyers and you saying, well, basically if that happens, litigation's the least of your problems.
Exactly.
I mean, that's what I think about. That's very much what I think about reliability. So yeah, I mean, if you prescribe it in detail, you get certainty in the sense that you've got one avenue that you could certainly say for the time being is a good one. But particularly, I mean, the way technology is developing, I was very conscious of not putting anything in the ETDA that wouldn't be obsolete in 10 years, 15 years. So, there are all sorts of ways that we might describe a reliable system at the moment that seem appropriate. and seem the right level, but in 10 years' time, they're going to look a bit naive, I think. So that's the difficulty with being prescriptive about it. And then I do think you stifle innovation if you're too dictatorial about what a reliable system looks like. So that's the sort of practical response. But I think the main one is, and again, it's about that comparison with paper. I would say to people, paper's reliable. Paper's a reliable system because you've got something that's unique and transferable, and you put information on it and you pass it to someone, and then, the law does the rest. And that piece of paper is reliable because it does what it says it needs to do. And so my point to users was, well, you're going to select a reliable system. Why would you not select a reliable system? Because if you don't select a reliable system, it's not going to do what you want it to do from, one day to the next. Now, I get, of course, that it isn't that simple, and the ex post facto, one party could certainly, if they wanted this document not to be valid, they could bring all sorts of arguments as to why the system was not reliable. But the point is that courts aren't stupid, and they're not, judges rather aren't stupid or naive. And if parties have been using a reliable system and both of them commercially believe this to be a reliable system, then of course that's a lot of persuasive material that actually the system is reliable. So, this is the question since the ETDA I've probably been asked the most. I think it's a bit of a red herring in legal terms. Not in factual terms, but then in factual terms, why would you select an unreliable system to conduct your transactions? And that's all that we're really saying, that it has been given a lot of airtime. And it's not that I'm surprised about that, but I don't think the solution is to put more in a statute.
I agree with you. It's like if a bank uses a solution, there's like, someone has that means reliable. No, you need to vet the solution yourself. You have cybersecurity policy. You have a system of audit that you perform yourself. It's not a get off jail free card to say that I follow the law and law says I do this, then I'm good. It's not about that, right? You all have a duty of care, of checking to make sure the system works, it's reliable. And in this system, actually, probably the person who's more liable is not even the bank or the customer, is a shipping line. They have to make sure that whichever solution they contract with is technically reliable, with regards to the definition of a country, right? Because in the end, if something bad happens, they're the one who's going to get sued. They are fully incentivized to make sure the solution they use is reliable. Yeah, I think go back to what you're saying. Yeah, it's just, I won't say common sense, but if you go run the scenario of a litigation, that will start to hit how did you start to use this solution that's not reliable?
Yeah,
and then the question becomes very, very obvious, like why you choose that, right? I think that's probably the most pragmatic answer to it. But
it's also, I think there's also a point about the culture of those different legal systems, because of course, French law is, codified law. So, I think it makes more sense probably to French lawyers than it does to English lawyers to have more detail in, regulation or legislation. And we're just not really used to doing that.
The way I look at it is like we're playing board games. English law is you playing Monopoly. With house rule, you have the precedents set up for the last 10 years and how we do things. And French law is almost like you play set of like 10. You have to read the 45-page rule book with every single situation spelled out. And you have to rule and debate on if the thing applies or doesn't apply. I think it's just two ways of doing things, right? Yeah. So now going back to MLETR, right? So because technically there's a lot of things that we've talked about ETDA, but ETDA also is aligned with the Untitled Model Law on Electronic Transferable Records, which is MLETR. So there's one thing that I personally struggle a little bit. So consulting as a law professor, you have ETDA, you have the law in Singapore, you have the law in France. You have many interpretation or implementation of MLETR, which is a model law, right? So what is the risk of the difference of implementation in different jurisdictions? But since they are technically aligned to MLETR, is there a risk if you are using Singapore law versus UK law or et cetera, et cetera?
No, not really. Because again, this is something that I was asked a few times, why didn't we just implement MLETR, which is pretty much what Singapore did. I mean, not absolutely, but there's not much difference between MLETR and the Singapore Act. And the answer to that question is simply that the MLETR, so the model law on electronic transferable records, is, as the name suggests, a model law. It's not supposed to be, as one of my research assistants described it, plug and play. It's a suite of principles, and it just wouldn't necessarily fit. So the ETDA is MLETR principles transposed into a different key, really. And that key is the common law of England and Wales. There's no, I mean, it's entirely compatible. So there's no substantive gap that would mean that a particular document would be, say, whichever way round you do it, would be valid under Singapore law and not under the ETDA, or vice versa. That's certainly the idea, and that is certainly the principle. I mean, obviously, with adversarial systems of law, there may well be an argument made to the contrary that succeeds either for good or at least until appeal. But the point is, as far as the statutory principles go, they are entirely compatible. There aren't any conflicts between those principles. We didn't disagree with any of the sort of direction or the ethos of MLETR. It was simply a case of making it fit within, as I said, sort of hook into the English law that we already had. So that's the only reason really for the difference there. And I think, I've only had a couple of days to digest the French decree alongside, what I'd already seen of the French implementation. And I think so. I spent a lot of time talking to Philippe Henry, who clearly was, the driving force, I think it's fair to say, with this. And I think the same is true there, that, there's no, they might look to the untrained eye as if they're doing very different things, but they're really not. In substantive terms, there's a huge amount of overlap. And so far, I've not really identified any gaps that a document could really fall between. They're all about recognizing that where an electronic document emulates a paper document, it will be treated in the same way as that system of law, i.e. France or Singapore or UK, treats paper documents. So to the extent that there is a difference, it really is just carrying on a difference that was there anyway for paper. And there aren't that many of those, because, the interesting thing about international trade law, and it's quite a hard message to land because it's more about the practice rather than the principle, but commercial parties in international commercial litigation are very, there's certain points that they just in practice agree not to litigate. Obviously there are going to be some things that they will focus on for a given dispute if they really want to win it and they've got loads of money and infinite time or whatever, but they don't take every single point. So there is quite a lot of sort of collaboration and, harmonization in terms of, because there's always going to be, and this is a very difficult question for any transaction with an international element, whether it's electronic or paper or whatever it is about, there's always going to be a difficulty in that different systems of law treat things sometimes slightly, sometimes very differently. You can never, ever guarantee that absolutely your dispute is going to go to the courts of Singapore or the courts of France. And, so you never know exactly what rules are going to apply. But although that looks like a very scary principle, because it's absolutely, as a matter of fact, true, it's not as bad as it sounds, because there is, there's a lot of sort of, and this is a very un-PC way of saying it, but the sort of gentleman's agreement, that there are certain points that parties are just not going to spend their money, litigating. And if there is a legal system and a set of legal rules that they're both quite happy with, they'll probably just accept it.
I think that probably speaks to the fact that people are playing an infinite game and not a single round game, right? Exactly. So if you play a single round game, you go for the kill, right? You want to maximize return. But knowing that you may have to face the same counterparty another time, you don't want to waste the time on stuff that technically you know in your heart of heart that probably wasn't as bad as your lawyers think you could claim. Right?
Yeah, that's exactly right. And particularly in international commerce, particularly in shipping, because, there's not that many parties. So,
exactly.
So the likelihood of you being able to say, right, well, I'm, as you say, go for the kill and then I just won't have anything to do with them anymore. Well, you've kind of really cut your nose off to spite your face then.
Exactly.
Because there are very few parties. And so there's actually a whole theory, certainly in English contract law, or UK contract law, I should say, about what you've just referred to, relational and discrete bargaining. So where you have a discrete bargain, you're far more likely to take every point that you can and to litigate. Whereas, of course, if it's a repeat situation, then you're probably not really going to be that bothered about all the legal points that could apply, because you're not spend money arguing about those things. And of course, then that changes the contractual relationship to quite a large degree.
Yeah, no, absolutely. I think we've devoted enough time on ETDA and MLETR. I want to spend the remainder of the podcast episode talking about digital assets. The reason for that is that over the next few months, I think there are a lot of exciting things happening in the world, right? So starting with the stablecoin legislation, US with Genius Act. In Hong Kong, we just had the Hong Kong ordinance just passed. So before we talk about stablecoin, let's first talk about the work you've done on digital assets, right? What is the consultation that you did as law commissioner? Okay.
No,
Yeah, yes, still you. It's not as much your baby as ETDA, but you're still involved in that point.
It is. It's more my baby, I think.
Okay, sorry. Why digital assets needs to have property rights, right? And how to imbue a digital asset with property rights. What's the best approach to do it? So can you talk a bit more about this?
Yeah. So this again so to go back to what I said about my time at Accenture and realizing that law was not going to be able to keep up with technological developments, and then weaving that into what I said slightly later about the double spend problem, and that digital things, I've never used that word as much as I did during these projects, so that deliberately generic use of the word things, that they just look very different to digital creatures of sort of 2 or 3 decades ago. So we have, if you cast your mind back to when I started the Digital Assets Project 2020, 2021, where NFTs as NFTs were a big thing, Beeple and the board Apes. That
I
people
had some.
Did you? Well, you'll know then. You'll definitely know. People were investing in some cases. What was the Beeple one? It was 60 million, was it?
From some context, I think that was around the time just before GSBN got incorporated. I did buy some NFT, which if you comparison, one NFT was costing roughly the same amount as Rolex watches that hold the prices. At that point, I think for a lot of people, the idea was a digital asset is actually real. It's a property you can touch. And actually, I had an Apple Watch where I still have the NFT picture on the watch. But obviously, it's nowhere near what was worth when I bought it. Sorry.
No, that's a perfect example, because people were spending all sorts of different figures and different levels of money on NFTs. To some extent, it doesn't really matter what you spend, just the fact that you spend anything at all and you buy these things. What was not clear to non-lawyers, in fact, I say non-lawyers, some lawyers as well, unless you're a personal property lawyer or particularly interested in this area, you would presume that if you hand over money in exchange for something, that you're buying it in the way that you buy a Rolex. And that therefore, in engaging in that transaction, lawyers would say technically a sale, that you, as a result of handing over money, you get property rights in that thing. And they're really important because your property rights in your things dictate what happens when things go wrong. So if somebody interferes with your possessions, so everybody, I think, knows that if you buy a car and somebody steals your car, or just drives your car away. Let's talk about it in civil law terms, right? So even if they don't mean to steal it, they think it's theirs, right? So take that. So they take your car away. You can't drive your car because they're driving your car. You have legal remedies, and you have, I think everybody instinctively knows, even if they don't know the technicalities, they know that if somebody takes your stuff, you have a legal remedy for it. And that's because of property rights. And it's because you have a property right that you can enforce against what we'd say as lawyers, the world, like everyone who interferes with your property, you have a right against them. And you don't have to have made, so they're different, and this is important, they're different to contractual rights. So I could agree with you that, you do certain things, I do certain things, that's a contract, but nobody else is affected by that contract, it's just me and you. But a property right, as I said, is different and in a lot of ways more valuable because I don't have to have a pre-agreement with anyone. If I have property rights in that thing, nobody can touch it, whether I've agreed with them or not. So it's an important right. And it's an important right in terms of insolvency, because if I buy something from you and I have a property right in it, but you've still got it, so I don't have to possess it for it to be my property. So there's quite a few examples where, NFTs, but if we take a conventional example, quite a few people will buy gold bars and then they will store them with the seller. So they're theirs. They've got the property interest and the value is theirs, but physically the gold bar, because what are you going to do with a gold bar at home, right? So you store it with it. Now, when that gold merchant, or if that gold merchant goes insolvent, it matters very much whether you have a property right or a contractual right against that merchant. If you only have a contractual right, you'll probably never see that gold bar or its proceeds again, because the secured creditors of that merchant will rank above you. If you have a property right, that thing is yours. It's good against the whole world. It's good against those creditors, so you get it back. So in commercial terms, and it's a very basic example, but it's really, really important. And it matters in a consumer context. You hear about all these situations where people pay for sofas and they pay in full. And then before their sofa is delivered, the company goes insolvent. They lose their money. They don't get their sofa. So it's really, really important to have a property right in something rather than a contractual right. So rewind to 2021 to 22, people were paying quite large amounts of money for digital assets, having no idea that actually they probably didn't have a property. They thought they were getting the same rights as buying a Rolex, but actually they weren't, because the law at the time didn't really process property rights in digital assets. So you'd have this contractual right because you'd paid money, but as I've just explained, I hope, that doesn't necessarily help you, and it might help you, but it's certainly a far less valuable and robust right than a property right.
So if I make it more concrete, 2022, when FTX went bankrupt, and you hold Bitcoin or Ethereum on FTX, if it's construed as your asset, then you'll rank much higher in the bankruptcy proceeding. If it's a contractual agreement where you say, I enter in a contract with FTX where I buy from you, you hold it on my behalf, it's a contract, which I don't physically own the digital asset, then I'm kind of screwed, because first, all the creditor who's above me in the waterfall gets their cut, right? You pay the staff of FTX, you pay the senior creditor, the lender, all the people who they own the money, and you're at the bottom of the waterfall. In the other way around is you at top, because technically it is yours, and no creditor can touch it effectively.
Yes. Yeah. So, I mean, I think that the actual ranks of creditors differ across jurisdictions, but however it shakes out, if you've got property rights, you're right, you're a secured creditor, so you're further up. If you've only got contractual rights, you're an unsecured creditor, so realistically, you're not going to get very much at all. So it really, really matters that you have a property right.
That's a big difference. Yeah.
It is a massive difference. It's a massive difference. And it also, the important thing, and the thing that's come out in recent litigation, it's not just about insolvency. It's if somebody hacks your wallet, for instance, again, to use a very generic example, if somebody hacks your wallet and takes whatever is in there, then, again, without a property right, you don't necessarily have a remedy in the way that you do. As I said, you presume that if I buy a car and that car is mine and somebody drives it away, then the law will give me a remedy because I have property rights.
So if, let's say, I have a hardware wallet that contains the private key of, let's say, a Bitcoin wallet. So you're saying if someone take the private wallet, and with it the private key, which give access to the Bitcoin, technically from a legal perspective, if property right doesn't apply, I don't really have a recourse to it.
Yeah. So, certainly back in the early 2020s, it was not at all clear what the legal response to that would be. Exactly. So I used to go and do these talks and say to these rooms full of people, well, if anyone's bought any of these digital assets, it's not clear that you've got property rights in them. It's not clear that they're then yours, that you can enforce any. I know. It's just amazing. The reason is, I touched upon it with the ETDA, is that legally, we had all this centuries of property law, but it depended upon the thing in question being possessable. And possession, that's the really key concept here. And so again, if we're talking about the sort of the civil law situation, if you drive my car away, I have what's called an action in conversion against you. If you take my car, I can sue you. So obviously there's theft, and most people are sort of aware of that, but there's also a civil law claim, which is of course very important. I can sue you. You have to give me the market value of the car if I'm successful. So that's what a proprietary remedy gives me. And there's all sorts of situations where, of course, that's massively useful in a commercial sense and a private sense. But it depended on possession, and it depended on possession because you needed to be able to have that thing. That thing needed to be able to be taken away from you, and your interest in it, completely divested. So obviously, if you're driving my car, I can't drive my car at the same time. And so what was not clear, as I said, we've got this 2009 authority that says intangible assets can't be converted, and it was about accounts receivable, so it's about debts. You can't convert those things because essentially the important legal point is if you owe me money, nobody else can interfere with that. Only you can settle that debt, basically. Whereas, of course, my car, anybody could take my car. So there is a real difference there. So in order for us to transfer that debt, and of course that happens all the time in commerce, you sell debts because they're valuable things, but you need a legal process to do that, and you need consent. Whereas anybody can take my car factually, like doesn't give them a better legal title than I've got, but it gives them the car. And that is the really essential difference. So to go back to what I was saying before about the problem for English law was that for centuries we'd had things in action or shows in action, which are those pure contractual rights. So the debt is the classic example. So it's valuable, but it only exists because the legal system recognizes it and because we claim it. It doesn't have an existence in the world like my watch. Yeah. Whereas things in possession are all the physical things like laptops and bags of gold and whatever. I say bags of gold because there's loads of old cases that are still good authorities that are about bags of gold. So the real difference there is that what we've just said. So if I've got a horse, you can take that from me as a matter of fact because it exists in the world, you can take it. Whereas nobody, as we've just said, can take my debt from me without my consent, without a legal process. So that's the massively important difference. Because of course, if you can't take my debt from me without my consent, I don't need a possessory remedy because it can't be taken. Whereas all my things in possession can. Now, so the question was, so where do digital assets fit? And as I said before, I'd written about this for many years. And my point was, well, actually, modern digital assets are more like things in possession. There's a natural tendency, certainly by non-technologists, to see them as things in action because they're often referred to as intangible because you can't hold them, you can't pass them on. What is important is that modern digital assets like NFTs, which are now, of course, not just sold for their own use, but used for very useful things like governance tokens and security tokens, whatever, they are more like things in possession because they do have a physical existence in the world. Some people struggle with the notion of it being described as physical. So I think what's important is they are independent of people and the legal system. So as I said, the thing about a debt is it's only there because the law recognizes it and because you and I claim it. Whereas an NFT, so take a Bitcoin, I'm going to use a Bitcoin just because everyone knows, thinks of Bitcoin. But a Bitcoin exists in the world. It is there somewhere. It has an independent existence. And even if the legal system disappeared and if people disappeared, Bitcoin could well still be there. Or an NFT could well still be there. So it's independent and it's rivalrous, which was a word I was never wild about. But even through a whole of consultation, nobody suggested a better one. And that's just simply the double spend issue. If you're driving my car, I can't drive my car. If you've eaten an apple, I can't eat the same apple. And of course, with an NFT, if I have control over it and I'm spending it, you can't spend it. And I can't spend it twice. And those two things are really important, independence and rivalrousness, because they take digital assets from the things in action, pure contractual rights thing. They can't be because they're not dependent on the legal system. And they make them closer to things in possession. It's difficult for a lot of people to regard them as things in possession because you can't hold them and touch them, which is one of the reasons why we decided that the third category, actually just a fresh, third category, would be a cleaner way of doing it. But what's important about independence and rivalrousness is that it makes things, and again, this is another not ideal label, but it does say what it needs to say, is it makes those things involuntarily alienable, i.e. they can be taken without my consent. And that means, and as the cases have shown, people can hack into my wallet and take all my digital assets in the same way that it could take my car. You can't do that with a contractual right. So you need the law to respond in a particular way to those digital assets. And it just wasn't doing that because it was treating them as intangible, saying they're like contractual rights. I hope I've explained why they're not like contractual rights. And so they do need these possessory remedies. So the third category, as I said, was what came out of consultation. There were consultees who said, yeah, they do look like things in possession, but they also don't because they're not something that you can transfer in the conventional way. And of course, depending on the platform or depending on your interpretation of a platform, if I transfer, say, a Bitcoin to you, it's not quite the same as me passing you my Rolex because arguably what leaves my hand or my wrist is not exactly the same as what ends up on your risk. It is in value terms, but it's a thing that might morph, like, be extinguished in my account, created. So some people said to us that might be a difficulty with trying to get it into the things in possession category. So, you're the Law Commission, you can do this through recommendations, you could do a statute. Why not? These two categories have worked for centuries. Well, certainly a couple of 100 years they've worked.
Yeah.
And they've worked because everything was one or the other.
Yeah.
And actually the thing about digital assets is that, arguably they're not one or the other, and that they might have characteristics that are very similar to things in action, but they're not quite the same. And, why would we try and shoehorn them into that category if we could start again without the historical baggage of that category, still be able to take advantage of the precedent by saying that if and when appropriate, we can take that precedent and apply it, or we can get the courts to apply it by analogy to the third category. And rather like the ETDA, what's really important is this isn't just everything that's digital and intangible goes in that category.
Yep.
Again, there is a threshold. And so it's not everything, it's not every PDF or Excel document or email file. It's those things which demonstrate and exhibit the characteristics of independence and rivalrousness, and that therefore can be involuntarily alienable. Because there's all sorts of digital assets, as you know, which actually get their value from being shareable and infinitely shareable. And
MP3, books, PDFs.
Exactly. That's what we want them to do that. But there are also assets that get their value from being like a Rolex. There's only one of them and it's mine. And when I pass it to you, I lose the right to it. So that's the sort of skeleton of the digital assets project. And really what we did was, a very long consultation paper and a fairly long final report. We decided that all of the rules that I've just talked about in terms of possessory remedies are all common law. And the idea of property in English law is a real common law concept and has developed over time. And we didn't want to lose that. And we didn't want to, even trying to put that in a statute would be incredibly difficult. And I just don't even think it would be very helpful, to try and define exactly what property is. It's far more of a question for the common law of, we'll know it when we see it, and sort of incremental development. So what we decided to do was produce a final report that had an analytical framework that courts could use to show them how to apply property concepts to digital assets. And what was really interesting as part of this process is we consulted with the judiciary as well on all our projects, because of course they're the ones that are going to have to implement it.
Have to use it.
Yeah, exactly. And particularly with this, because we met with them, the senior judiciary, and we said, we're proposing to give you this guidance, but basically to hand it over to you and say, develop
passing the buck to them.
Yeah. Are you okay with that? I mean, I knew that they'd probably be quite pleased with that, because I think, again, it's a very English thing not to dictate too much to the judges. You have to.
Yeah.
And as the Law Commission, of course, constitutionally, we can't dictate to anyone. So we met with them and we said, look, these are our proposals. And the aim is that we'll do all the analysis and hand it over to you as a guide to the extent that you need it. Are you okay with it? And just because there'd been all of these years of precedent of things in action, things in possession. And in fact, there'd been recent cases in the last 10 years where these sorts of arguments about, one was about a database, for instance, these arguments about something electronic or digital being the object of property rights and being involuntarily alienable, it wasn't put in that way, but that's essentially what the argument was, had been put to judges, certainly up to the Court of Appeal. And a couple of them had said in their judgments, well, I do find these arguments quite convincing, but it's a big step. And we've got this House of Lords authority that says intangibles can't be possessed. And there had been actually, in a couple of judgments, an explicit reference that said Parliament needs to look at this. As a judge, I can't do this. So Parliament and the Law Commission needs to look at this. So it was a sort of passed it to us, and then we were
passing it back to them.
But I was delighted because being able to point to those judgments and say, look, to government, look, the judges want us to consider this. And we needed to, because it needed a huge amount of analysis, too much for judges and counsel to do when they've got other things going on. So we spoke to them about it and they said, yes, we do agree. And we think it should be a common law development because it will change quite quickly over time and the common law needs to respond to these different assets. But we would find it really helpful just to have a short, unblocking statute that basically says, yes, you you can have this third category, and that's it. So I mean, that statute was the result of the judiciary asking for it, which was really interesting. And we did have this workshop with them, and there were all sorts of drafting suggestions made. And ultimately, what that one provision of the Property, Digital Assets, etc. bill says is, it doesn't mention third category explicitly. It just says, more elegantly than this, because it was written by Parliamentary Counsel and not me, but it basically says something should not be denied proprietary recognition simply because it doesn't fit within things in action, things in possession. And that's it. And so it really is just unlocks that common law theory and development, so that then a judge who is persuaded by an argument that a particular digital asset is involuntarily alienable, for instance, and then should be the object of property rights, they can point to the Act and say, this is why I'm doing it, because otherwise it feels like quite a constitutional leap from what had gone before, simply because all of that common law history hadn't really had digital assets to consider. So whilst we were, and that bill, by the way, is nearly at the end of its journey, I'm fairly confident it will pass now. It's been through the House of Lords, it's had 3 readings in the Commons, so we're nearly there. But it's not absolutely necessary in the way that the ETDA was, because we're not reversing a statute. So actually, the courts could do it on their own. And in fact, in the time between 2020 and 2025, when we did this project, the common law has already moved on quite considerably. So we started off and there were only a couple of lower level cases that considered these issues, whereas now I'm sure you're aware, I'm sure most people who are interested enough to listen to this podcast will be aware that there are now quite a few cases where, for various reasons, the question of can I have property and digital assets has been addressed by courts across the world. Can they be the subject of a trust if it's a common law jurisdiction? Can they be the subject of an injunction or a freezing order? So the common law is already on its way and has made significant developments. I mean, some of that has been in response to the work we've done. So, for instance, there are a few cases in the US that referred to our consultation paper on digital assets. It was a big Celsius bankruptcy case. Don't know if you remember that.
Oh, right. 2021 is painful. It was very painful.
And, there was so little on this. And of course, lawyers, we've already talked about this. In the common law tradition, lawyers are so used to being able to point to loads of precedent to make their point. And of course, with digital assets, it's not there, or it certainly hasn't been there for a while. And it was the judge in that case who said, there's very little written on this, but the Law Commission of England and Wales have done this consultation paper, and these are the arguments as to why digital assets should be treated in a particular way. So we're getting there. And I am now reasonably confident that, actually, I'm now very confident that the common law will get there on its own anyway. I think obviously I want the bill to be passed now, just simply because I've put so much work into it. And unusually, so as Law Commissioner, you are what's called the principal witness to the Special Public Bill Committee. So it's like a sort of supercharged viva. You have to go to the House of Lords and they question you and sort of grill you for an hour. And unusually on the Digital Assets Bill, and then they listen to opposition or support. So they listen to other people that they've invited. And unusually, in fact, I think uniquely in the Digital Assets Bill, they called me back for a second.
Oh, wow. Okay.
They'd heard so much from elsewhere that I then went back and did a second session. So I really want it to work now, partly because the judges asked for it, partly because we put so much work into it, but also because I think, although we don't technically need it like we did with ETDA, I think it sends a really important signal. Yeah. And not only does the fact that we've considered it as a legislative concept send this signal out, I also think it would not look that great if everyone knew we'd considered it and then rejected it, because then it looks like we're saying something we're not, which is we're not as a jurisdiction interested in digital assets. And like the ETDA, it's not mandatory. It doesn't make the courts do anything. It doesn't make any changes. It just allows them to do it where, when and where they think it's appropriate. So that's where we are with digital assets.
Well, that's super interesting. So what I take away is 2 things, right? Number one is a lot of the action you take as law commissioner is try in the parents of technology is to create something that's backward compatible. You want to leverage the body of work before, and as you put it, right, try to do a very targeted surgical strike to change the smallest part you need to make it work. The second thing that's really inspired by what you're saying is digital property, the property for digital asset bill is really kind of creating a framework to say to give the judge authorization to say, I need somebody else to give me the authority to do this. And you're saying effectively, this is a new framework to consider. It's only debated. We think about it, right? We boil down to the two only element that matters, which is independence and rivalrousness. That is, if you have these two, then you can have a third category, and you don't have to use it if you don't agree. But to the extent you agree that something's missing, this is a tool that's available to you. That's actually a really elegant way of thinking about it. And I think that's maybe the one reason why UK law is so successful over the years, right? Just to make sure that you both provide a sound system, but also rely on the judge to make smart decisions. And these two combinations really make it work. Just very, very strong rule with dumb judge doesn't work. Very strong judge, but with no framework, that's not going to work either. So that's really the secret recipe why UK law is so good for commercial.
Yeah. And I think that's the politics of the legal system. That's another one of the reasons why we couldn't just implement MLETR, because it takes insiders to understand quite how all those little pressure points work. And you do have to be sensitive to the amount of guidance that judges want and need without treading on their toes, and without telling them what they already know or being over there. That just does not work within the English legal systems. That's the only reason really why. I mean, I always think, or I often think, it looks as if, we're not playing nicely with the other children because we're always like, we're going to do our own thing. But that's why, because I think it is a very peculiar system. And yes, it works well, but you need to appreciate how it works in order to get the right results. So that's the path that you have to tread as a law reformer in the UK.
This conversation is fascinating. I think next question is so it feels like the UK empire kind of is not at the same level as it used to be, but the UK law is actually punching way above its weight today compared to the economy, the UK economy, right? I guess legal reform is one thing. Right. The second thing is probably regulatory, right? So for digital assets to really work, probably in the FCA, all the regulators in UK to propose a similar good regulation in order to strive for the development of digital assets. Otherwise, just have a good legal framework doesn't really help if you realize very conservative. Similar to US, I think SEC has done 180 on digital assets, suddenly everything is a go. I think HKMA, SFC is kind of between the two. It's like, yes, we support, but we want the thing to be safe. We don't want to create instability. Feels like UK is kind of not having taken a position yet. So what's your feeling with regard to the regulation in UK right now?
Well, exactly what you just said, actually. It's it is a frustration because private law is one thing, that's the basic principles, but actually it's not the thing that non-lawyers day to day really care about or think about. So, as a commercial party, the lawyer that's advising you is going to know how your assets are classified and care about that, and maybe your accountants, but you don't. What you care about is what you can do with those digital assets and what you can't. And of course, that's the subject of regulation. That's not what we've been talking about today. I think the success of a jurisdiction in terms of how accommodating it is of digital assets stands and falls by its regulation. And the certainty and predictability, and also the flexibility. And certainly early on, as the Law Commission, we have nothing to do with regulation. That's separate. And as you say, that's the FCA, it's the PRA. But we worked alongside those two bodies. Of course we did. We spoke to them about what we were proposing and they did the same. And on the one hand, I was very encouraged that over those 4 years between 2020 and 2024, the mood music from the FCA certainly changed quite dramatically. When I began, there was very much an attitude. In fact, I think this might have been a verbatim statement almost from somebody there that, we're not going to roll out the red carpet for digital assets. It's like, well, I don't know why not really. As long as you do it properly, But anyway, so that was very much, I think, illustrative of the whole ethos at the time. Now, it's fair to say that has changed. And so there are, as I said, there's definitely encouraging movements. And I think you will probably have seen that there's been, Bank of England and FCA consultation papers quite recently on this. Yeah. And there does seem to be, which I'm very encouraged by, an approach which is based on, risk rather than type. So this is what I'd been saying all along, that we've got to see these things as rather than obsessing about their physical characteristics or their lack of physical characteristics, it's about their functionality and how parties use them and their risk profile. And if they have the same risk profile as a conventional, say, security, then why would you not regulate them in the same way? Rather than trying to sort of start anew just for digital assets when actually they're used in the same way. So, and the recent consultation from FCA does seem to be approaching it from that perspective. And that's quite a dramatic switch and a very important switch. But I think it's too slow. In fact, I know it's too slow because when I speak to the people I speak to in this world, the sense I get is that we're already being left behind. We're not really seen as a significant jurisdiction for investment because of the regulatory uncertainty. And I think that's a real shame because the foundations that are there in those papers, and the FCA has also, and the Bank of England set out a plan. Again, that's a very English thing, very cautious and I went on at the start about how important it is not to change things too quickly because that's our sort of reputation. But there's got to be a balance struck, and people, we've already said this as well, entities and organisations, once they've put their eggs in one basket, they're unlikely to remove them unless there's something dramatic that comes along. They're unlikely to remove them from that basket and, go to the hassle and expenditure of putting them in a new basket when those regulations change. If they're happy in the first one, that's, so we've missed early adopter advantage, I think, already. And I think that is a shame. I think when we get there, the approach will be a sensible one and will be a constructive one, but I wish it had already happened.
Yeah. I think the parallel I draw is for stable coin and what you can put on chain is a bit similar to what happened in 1996. There's the CDA, the Common Decency Act, Section 230, which is a special provision that gives a lot of liability coverage for those the platform. Essentially, it says that you are not liable for what's put on the platform. And that's actually really that opened the door for back then eBay, Amazon, all those things. Essentially, they're publisher, but they're not responsible for what's put on the platform. And that was a big get out jail free card all those tech company, internet company back then got. And that's why they went so fast and experimented, did a lot of things. Now you may argue maybe it was too much of a free reign for those companies to do a lot of things that potentially are not that good for society or for people in general, right? In terms of privacy and things like that. And the response in Europe has been GDPR.
Yeah.
And I feel maybe there's a similar thing that's at play again, but in the world of digital money and digital assets. Because you have the Jones Act in US, plus SEC that's much more permissive to experimentation. And depending how you respond, then the developers, people who are innovators, right? They'll be sucked into the location where regulation are more transparent, more clear, and more supportive of innovation. May not be a good thing because there's a one thing about a digital asset. You just keep trying to relearn all the mistakes of traditional finance in digital finance. But at the same time, it's undeniable that with all the regulation that's passing in US will become so strong and attract all the developers and things like that. And then if you do not have a strategy, you just watch for the next 5 years, things are going to be very different. And unfortunately, the way I look at it right now is probably there's only 3 jurisdictions has a chance to potentially compete. One is US, very, very strong contender. Abu Dhabi, Dubai, Middle East.
Yeah.
Very strong. And then Hong Kong, right? And the commonality is kind of all 3 follow sort of common law. So I feel what's happening for the legal aspect also is it's a bit sad because the foundation is built on UK law, common law, to give this ability to administrate, to adjudicate those different cases. But the regulation are all, I think, probably more permissive today than in UK. And therefore, maybe that's why those transition will go faster. That's how I feel, at least when I talk to people.
Yeah, that's exactly how I feel too.
Yeah.
And as I said, it's exactly what I'd have predicted. I think it's what everyone would have predicted, right? This can't be a surprise to anyone.
Yeah. Actually, if I may make a metaphor in blockchain parlance, it feels like UK law is the Ethereum, right? Is the Ethereum. US, Hong Kong, ADGM, right? Abu Dhabi Global Market. Yeah. They are basically EVM or it's virtual machine compatible or the chain L1. And they're basically relying on the developer who has been trained on UK law to suck all the liquidity away to those chains. That's effectively what's happening. Ethereum was really well designed, really robust, but eventually all the L1s try to attract the liquidity away. That's, I feel, a bit the metaphor of what's happening today.
No, I think that's right. I think that's a great metaphor.
Sorry. Maybe the podcast is very, very, very sad. No, I really enjoyed it. Thanks so much, Sarah, for this podcast. I think I learned a lot. And I think you really bring to life the different aspects that you had to consider to change the law. And also, I really appreciate that really what you try to do is try to do the minimum you can to solve a business problem. So that's actually really, really refreshing.
Okay, well, I've very much enjoyed talking to you about it. As I said, thank you for asking me on.
We have the last question we have. That hopefully you had a good time. If you have any other guests that you think can suggest for the podcast for Schelling Point, and if you have a name, why would you think that person is good for this podcast?
I mean, there is somebody who definitely springs to mind straight away. I think it might be quite an interesting perspective. Is Luca Castellani? Have you had Luca on yet? Sure. Obviously the godfather of MLETR, the architect of MLETR. I mean, he's the first person that I'd think about. He and obviously Chris Southworth. I don't think you've had either of those on so far, have you?
Okay, no, great. I think I know both of them. Thank you for suggesting it. Thanks a lot for your time today. So thank again for joining us today on the Schelling Point. If you liked the episode, please comment, like, subscribe, and share. Until next time on the Schelling Point, where ideas will meet again.